All right, we have the recording underway. But yes, thank you again. So to start off, Shawna is gonna go through some of the current tenant protections, and then I'll go over some of the new laws. So I'll turn it over to Shawna.
Good evening, and it's great to see you all here tonight. And we're hoping to share some important information and also get some information from you about what you're seeing out in the community and how we can be helpful, and any suggestions you have. There's been a lot of change in housing law in the last year because of the pandemic, and but there are some things that have not changed and that are really important for everyone to know, so that you can protect yourself. The first thing is that your landlord cannot cut off your utilities, lock you out of your home, make it impossible for you to use your home. That sometimes I've seen some other creative ways that this happens. Because if they do that, then you can go to the court and ask for relief. And what it describes under there is the petition for relief from unlawful exclusion. And you can find that form on the court's website, which if you just Google Virginia courts, you'll come to a webpage, it'll have forms. And when you search for the forms, if you just put in exclusion, this is the only form that has that word in it, and it will come up. It's easy to complete it online, and you file it with the courts, and there is no cost for this. And then what you can ask for is for the court to order that the conditions that are keeping you out of your home be corrected. You can ask for your actual damages. You can get reasonable attorney's fees. And as of July 1st, you'll be able to, if the court finds that you have been excluded unlawfully, you can get $5,000 in a penalty. So we haven't had any experience with that yet. It's a new law, but it's exciting that that's going to be available. You can always, of course, call our office. We have offices. I'm in the Lexington office. We have offices in Harrisonburg, Winchester, and Roanoke. Please do call us if you find that you're locked out of your housing, or the water or electricity has been shut off. The second thing is that sometimes landlords just write you a letter and say you have to move. Well, they can write you a letter and say that you have to move, but that has no effect unless they file something with the court and follow through the process. And so we sometimes have people call us, often have people call us in a pretty panicked because they have gotten a letter and they think, oh God, I have to go today. You don't have to go today. Filing the case or just a letter does not mean that you have to move. Then the subsequent thing to that is sometimes you go to court and the landlord wins and says, okay, now you have to get out. Well, there are some other tools that you can use after that. Sometimes there's another bite of the apple if you file an appeal, depending on various issues, and it's good to call us if you want to appeal. But also, they can't evict you until 10 days have to pass, because that's your appeal period. So they don't evict you during that time. And then they have to get what's called a writ of eviction, and it has to be served on you by a sheriff. And after it's served, you still have 72 hours at a minimum. So those three things are important to just remember if you find yourself in that situation, that you are not without some tools to use. Now, the situation is a little bit confusing now because this is a federal protection, and it's the eviction moratorium, and the previous protections we're talking about are state protections. This is a federal protection, and it started last September, and now it's about to end on June 30th unless it gets extended again. People are not optimistic, but it's possible. However, in this last period, between now and the end of the month, people certainly should take advantage of it if they find themselves unable to pay their rent, because this protection is for people who are behind in their rent. It doesn't protect you in other eviction circumstances unless the landlord is using the other circumstances as an excuse to try and evict you. And that we have seen some of that. But in order to get this protection, you have to take some actions. And there are certain people who are protected by this. And as I said, your inability to pay rent doesn't have to be related to COVID. It can be related to, you lost your job. It just happened that you lost your job. It doesn't have to be for that reason. You could have been fired. But if you're facing an eviction and you have tried to get government assistance, and that's a part of it, and you've tried to pay to the best of your ability, then the moratorium is available to you, and you will, in a couple of slides, we'll have a link to find the form. But the form is really simple. The one side is, do I qualify for the moratorium? And these are to do with your income and any benefits you may receive, government benefits, and things that have happened to you over the last period of time. And if you can say yes to at least one in each of these columns, then you qualify. And then you declare that you are eligible, that you have tried to make payments, that if you were evicted, you would have no place to go other than be homeless or to live in a crowded housing situation. And once you've done that and given it to the landlord, and do keep a copy of it for yourself, this, and at least until the end of this month, protects you from being evicted for non-payment of rent. And there's some suggestions in here, and you can send it by certified mail and hand a copy, but do keep a copy. And here's the link to the declaration. And it's best probably to use the official declaration, although you can just make your own, but this makes certain that you cover all the things that are required. And now we're back to a state program, which is the rent relief program. Now, they have been given a lot of money, and there's been some hiccups in getting the money out to people, but people have been having their rent covered by this, and if you meet the criteria, you can get your past due rent paid too. And it makes tenants very happy, and it also makes landlords very happy. So the eligibility is, the first thing is you have to have a lease or be able to show a landlord-tenant relationship. And sometimes I've had the most success in cases where the landlord doesn't want to do another year lease, or maybe the tenant doesn't, just to do a formal month-to-month lease. And most landlords are agreeable to that when they know they're going to get some money from it. And then you have had to have experienced a loss of income, and the loss of income must be somehow related to COVID, but almost everyone's loss of income over the last year has been somehow related, whether it's because they had to stay home to take care of their children, or where they work closed, or there were no jobs available because of COVID. So most people have had a loss of income can show a connection. I haven't seen anyone who couldn't. you have a rent that is at or below 150% of the fair market rent. And I also, of course, our clients' incomes are maybe a little bit lower than average, but I haven't found a problem with that. And a current household income at or below 80% of the area median, but the area median is kind of stunningly high. I mean, it's like 60,000. So, you know, most people don't have a problem qualifying for that reason. And this is some directions on how to apply, and that you can apply online, and you can also call and do quite a bit of it over the phone. Although I've known people to do it by text, sending documents, because there's quite a few documents that are required. Mainly, you have to document your income, and the landlord has to document that they are a taxpayer, and that they and that you both agree to enter into this rental assistance. So it can be challenging to get the documents submitted. Sometimes with our clients, we often submit on their behalf. And we're about, throughout the state, there are going to be some people being hired to help people navigate this process. So please don't hesitate to contact us if you get into difficulty trying to submit your own application. The other issue is that right now it's the law that landlords must apply on behalf of their tenants if the tenant hasn't applied. That is going to end at the end of this month with the end of the state of emergency in Virginia. But if you, it's really, my experience in the past has been that the landlord's process was a little bit more straightforward, and also it makes the landlord understand that you're doing everything that you can to get your rent paid, and they're cooperating with you. So I would encourage you, if it's possible, to have your landlord apply on your behalf. If they're not willing, and especially after July 1st, you may have to do it, but we believe that we'll be able to make the argument if they don't help you with that, then they're not doing their best to get the rent that they're owed. And we will look at that as a defense to an eviction. This is another state law, and it's if you have lost income because of the pandemic and you're being sued for eviction of non-payment, you may qualify for a 60-day continuance. And that goes until 90 days after the end of the state of emergency, and which will be until the end of September. So anyone that has lost income because of COVID and has some kind of documentation of that, it is required to have documentation. You can go when you get the summons to go to court, you go to court for what's called the first return, which is the first time you appear. And then bring with you documentation of the fact that you lost income and ask the judge for a continuance. Laura, is that?
All right, I'm just trying to find the unmute button.
Oh.
So to add even another layer of confusion, there's other tenant protections that are going to be in effect through the end of the COVID state of emergency, which at this point looks like is going to expire on June 30th. This is what Shawna was talking about before, about your landlord has to apply for rent relief on your behalf. They also have to give you a 14-day notice. Previously, when a landlord wanted to evict a tenant for non-payment, they only had to give them 5 days notice to say, here's how much you owe, you have 5 days to pay or leave, or I will sue you in court. Now they have to give tenants 14 days. That part will still be in effect through next year, but there's other components that will expire at the end of the month. that being that the landlord has to apply for rent relief on the tenant's behalf or cooperate. Now, if rent relief is denied, either because the tenant refused to cooperate by not providing the documentation required, or if the application was not approved within 45 days of submitting the rent relief application, or if the tenant isn't eligible for rent relief, or if the program runs out of money, which is not going to happen, then the landlord can move forward with the eviction. But as I say, these particular protections will end at the end of the month. But there is parts of that continue on through the end of next year, and that is the 14-day notice requirement. And landlords also have to offer tenants a payment plan as an option to catch up on rent. The payment plan has to have equal monthly installments over a 6-month period. The one caveat is that if that tenant has less than 6 months left on their rent, then it would just be for however many months are left on that lease. So if you only have 4 months left on your lease, the landlord only has to offer you a payment plan with 4 installments for those remaining 4 months. And during that period, the landlord cannot charge any late fees, so long as the tenant is making those payments on time. And as long as that tenant is making those timely payments in full, the landlord cannot evict the tenant. Now, if the tenant misses a payment, the landlord sends a new 14-day notice, giving them an opportunity to say, hi, you're behind on rent, here's how much you owe, and an opportunity to pay it. But if that tenant doesn't pay within that 14 days, then the landlord can move forward to the eviction. Because all these different protections were in different bills, some of them overlap one another, but this is one of those bills that got put in place last year as a COVID emergency measure, and then has been extended through July 1st of next year, so July 1 of 2022. Another new law that passed this year that will be going into effect on July 1st is some changes around the right of redemption. So the right of redemption is what allows a tenant, even after they've been sued for an eviction, to pay everything they owe the landlord, including rent, any late fees, any court costs that the landlord has incurred by filing the eviction lawsuit. And if the landlord has incurred attorney's fees, as long as the tenant can pay all of that off by the first return date, then they get to stay in the property. But previously, the landlord was allowed to place some carve outs on that. Basically, they could have sent a notice to the tenant saying, if you pay me, then I reserve the right to move forward with the eviction, even though you've paid. Starting July 1st, that's no longer the case, with one exception, that landlords with 4 or fewer units can limit that right of redemption to once per lease term, so long as they provide written notice to tenants. But for all other landlords, they have to include clear language explaining the right of redemption and that 14-day pay or quit notice to clearly state that you have to pay everything you owe in order to stop the eviction. Any partial payment will not stop the eviction. They also have to give you, the landlord has to say the exact amount the tenant has to pay in order to cancel the eviction if the tenant asks for it, just so that it's clear the tenant, isn't paying what they think they owe and still get evicted anyways. That just makes sure that we're all on the same playing field, that the tenant knows how much they need to pay to become current, and not paying money into something and then get evicted anyways. And as long as the tenant pays everything they owe, the landlord has to cancel the eviction. So if this happens on the day of the court, the case would get dismissed. If it happens after a judgment has been entered, that tenant has 48 hours before that scheduled service eviction to pay everything they owe. And if they do that the landlord has to cancel the eviction, and they have to get the judgment marked as satisfied. So there'll still be an eviction judgment against the tenant, but there'll be something with the court saying that the tenant has paid off that amount, and the eviction will get canceled. Now, if there's a judgment entered and the tenant uses that extended right of redemption, and the landlord chooses not to cancel the eviction and lets the sheriff kick the tenant out, that will qualify as an unlawful exclusion, which Shawna talked about a little bit earlier. And this would allow the tenant to file something in court to say that they have been illegally evicted from their home. So this is a really big change to prior law. It gives a tenant more opportunity to, pay off anything that they owe and be able to still stay in the property. And it also requires landlords to provide clear language about what this right of redemption means, exactly how much money a tenant needs to pay in order to redeem, and gives tenants a little bit more time to make that payment. But like I said, this does not go into effect until July 1 of this year. Related to that is some changes around unlawful exclusion. As Shawna mentioned, that in Virginia, there's no such thing as self-help eviction. So, the landlord can't change the locks or do anything to make the home unsafe or cut off the water, electricity, can't do any of that. In order to evict a tenant, they have to go through the court process. Obviously, if you have a landlord acting on your own, this can create really unsafe situations for the landlord and tenant. So it's better just to go through the court. Now, if the landlord does use self-help eviction measures, the tenant does have some relief. They can file the tenant's petition for relief from unlawful exclusion and general district court. I know that's a mouthful, but you can find that court form online through the Virginia court's website. And starting July 1, the courts have to schedule that first hearing for that case within 5 days. So that means that if you were locked out of your property, the court has to hear it quickly so that you can get back in. Now, if you go to, there'll be a link at the end of this for the Virginia Poverty Law Center's website, where you can find more information about how to file an unlawful exclusion, more information about this. Or if you are locked out of your property, I strongly encourage you to contact Blue Ridge Legal Services to get you help as soon as possible. Another change related to unlawful exclusion is that starting July 1, tenants will be able to recover $5,000 in statutory damages. So if the judge finds that, yes, the landlord illegally evicted you, you can recover either $5,000 or 4 months rent, whichever is more. And you could also recover damages for any expenses caused by the illegal eviction. So if you were locked out for 5 days and you had to go stay in a hotel, and if you had like an infant and you lost all the infant's food and you had to go to the grocery store to buy more things, as long as you have all those receipts to show that loss of funds, you can recover that damages as well. So that $5,000 damages is going to be really helpful for tenants where the landlord is either threatening them or does change the locks, because you can go to the landlord and say, hey, if you don't let me back in right now, I can go to the court and get an order saying that you owe me $5,000. And so hopefully this will also be a really helpful negotiation tactic to get landlords to take this issue much more seriously. Another change that went to effect has to do with the landlord getting consent to enter your home during a pandemic. And this starts on July 1st. So a permanent change is that landlords have to give tenants at least 72 hours notice before doing routine maintenance in the building, unless you're the tenant's one who requested that maintenance. Obviously, if it's an emergency maintenance issue of, water leaking through the ceiling, that's an emergency and they can go in immediately. Previously, landlords only had to provide 24 hours notice, but now that's extended to 72 hours notice. Additionally, during a state of emergency based on a pandemic, such as COVID, that tenant can provide written notice to the landlord saying that they don't want any non-emergency maintenance conducted. This is because we know there's people out there who are immunocompromised, that don't want people coming into their home and potentially spreading illness. So this is to protect people in those situations. So there are some caveats to that you have to give your landlord notice that you don't want that non-emergency maintenance. You can only do it if there's a state of emergency based on a health pandemic, which, as Shawna mentioned, Virginia's likely to be ending its state of emergency soon. So, this won't be in effect until after the current state of emergency ends. And you can only do that once every 6 months, or the landlord can still do non-emergency maintenance once every 6 months, because there are certain maintenance that landlords are required to do to keep the building up to code or with their insurance that covers the property. But they have to give you at least 7 days written notice to the tenant before they do that, and has to be at a time that the tenant consents to. And the employee or the landlord and the maintenance workers coming in have to wear protective equipment so that they're not, spreading any illness. And this is part of the whole loan agreement that a landlord might have for that property. So those are some of the caveats that are put in there. But I think the biggest takeaway here that will be a permanent change effective July 1st is that landlords have to give tenants at least 72 hours notice before entering the home to do routine maintenance. They can't just show up whenever they want to go change the air filter. They have to let you know. Another big one is that there's a federal law called the Service Member Civil Relief Act to provide certain protections for our armed men and women serving in the armed forces. Oftentimes they'll get orders and called away at very short notice and need to break the lease. Now, there was a practice of a lot of landlords in Virginia who included a notice in their lease requiring tenants to waive their rights under this federal law, the Service Member Civil Relief Act. But starting July 1st, they will no longer be able to include that waiver. This is really important for those serving in the military and their families, so they can get full realization of those rights under the federal law, including a right to a continuance of any eviction case that might be filed against them, the right to break the lease early. So this is a really great change to support those in our troops. I know I just went through a lot of information, so at this point, I'm going to go ahead and stop the recording, and then we can do some Q&A.